Good morning, respected members. There is a landmark judgment from the Honorable High Court of Calcutta in the case of Suncraft Energy Private Limited versus Assistant Commissioner of State Tax. The gist of the judgment is action against supplier is essential for non-reflection of invoices before seeking reversal from the recipient. This is the gist of the judgment from the Honorable High Court of Calcutta. Action against supplier is essential for non-reflection of invoices before seeking reversal from the recipient. So, what action to be taken against the supplier? The Honorable High Court has categorically identified 4 situations and directing the department to follow all the 4 situations and must prove before directing the recipient of the goods or services for reversal. The department must prove the following. The first one is there must be a collusion between the selling dealer and the purchasing dealer. So the the department must take action against the supplier and must prove that there is a collusion between the selling dealer and purchasing dealer. And second one is the supplier is missing. The department must prove that the supplier is missing. And the third one is the supplier has closed down its business activities. So these are the conditions specified by the Honorable High Court and the department before resorting to reversal of the ITC from the recipient, and department must prove there is a collusion between the appellant and the fourth respondent, that is the supplier here in this case. And where the fourth respondent is missing, that is supplier is missing, and the fourth respondent has closed down its business activities, that is the supplier has closed down its business activities. And finally, the fourth respondent does not have any assets. The supplier does not possess any assets and such other contingencies. These are all the conditions imposed by the Honorable High Court on the department before resorting to the extreme step. And further directed, straight away the first respondent was not justified in directing the appellant to reverse the ITC availed by them. First respondent here is the appellant. So the final conclusion is and final direction is the straight away the first respondent, that is the department, was not justified in directing the appellant to reverse the input tax credit availed by them. So these are all the conditions specified and imposed by the Honorable High Court. And finally, therefore, we are of the view that the demand raised on the appellant dated 20th February 2023 is not sustainable. This is very important judgment and very useful judgment on the part of the recipient of the goods or services. And if any similar situation faced by our clients or our dealers and our friends, we must take a shelter on this judgment. The judgment is reported in Taxman website on 4th August 2023, that is today. Citation is 153 taxman.com 81 High Court of Calcutta in the case of Suncraft Energy Private Limited versus Assistant Commissioner of State Tax. So all the 4 conditions must satisfied before instructing the recipient dealer to reverse the input tax credit. I once again reiterate, therefore, before directing the appellant to reverse the input tax credit and remit the same to the government, the first respondent ought to have taken action against the fourth respondent, that is the selling dealer. And unless until the first respondent is able to bring out exceptional case where there has been collusion between the appellant and fourth respondent, where the fourth respondent is missing, that is supplier, and the fourth respondent has closed down his business activities, and the supplier does not have any assets and such other contingencies. So this is the gist of judgment. Try to go through and follow the same after analyzing yourself whether it is applicable in your particular cases or not, and frame your own opinion accordingly. Namaste.